Today's video is Forfeiture of Lease How-To Guide. This video is a summary of Forfeiture of Lease for a full article that has been written on that subject. What is Forfeiture of Lease? Forfeiture of Lease is the ending of a lease. Forfeiture occurs when the landlord exercises their right to regain peaceable possession against the wishes of the tenant. This is usually where the tenant has breached a condition of the lease or has breached one of the covenants. It's usually done by a bailiff who enters the property peaceably and takes vacant possession of the property on behalf of the landlord. It's a contractual right under the lease and is preserved under section 24(2) of the Landlord and Tenant Act 1954. Uses of forfeiture. This is a good tool if you can't execute commercial rent arrears recovery because the bailiff can't gain entry, or indeed because there are little or no goods to seize or the goods belong to third parties. At present, a landlord can forfeit the tenancy on several grounds depending upon the wording in the lease. The most common of which is for non-payment of rent, but others include where the tenant breaches the terms of the tenancy, insolvency, improper use of the property, subletting, or nuisance behaviour. The landlord could make a claim for damages, but the landlord may also wish to regain possession of their property. The landlord can only take this action to forfeit the lease if the tenancy contains a forfeiture clause. Depending on what the breach is for, the landlord may or may not have to first serve the appropriate notice under section 146 of the Law of Property Act 1925. Waiver the right to forfeit. If the breach is for non-payment of rent and the landlord has done nothing to waiver that breach, then the landlord can usually forfeit the lease without any notice. This is because non-payment is usually classed as being so bad that the landlord would not wish to continue the lease. The landlord must make sure nothing is done or said to waiver that right to forfeit. This may include sending in the bailiff to collect CRA, or trying to arrange an instalment plan or to issue proceedings. If this has occurred, then the landlord should wait until the next period of rent is due, then forfeit the lease for that month or quarter's rent. How to effect forfeiture of the lease. A landlord can re-enter the premises and forfeit the lease in one of two ways. This will usually be either by peaceable re-entry or via court proceedings. With peaceably re-entering the property, a landlord would normally instruct a bailiff to go in at a time where the property is empty, because if somebody is on the property that would oppose that entry, then the bailiff would commit an offence under section 6 of the Criminal Law Act 1977. Not to be used on mixed-use property. This method cannot be used if the premises includes a residential element and someone is in residence. In these cases, a full possession order should be obtained by the court before proceeding. Forfeiture can also be done by court proceedings, where a landlord can issue a claim in the court to forfeit the lease. However, this is usually a long, drawn and expensive option. Relief from forfeiture. A tenant or subtenant, or indeed a lender, can apply to the court for relief from forfeiture to allow a tenancy to continue. In practice, however, the court can impose conditions which might require the tenant to pay any rent arrears or remedy the breaches before this is heard. Goods inside. If the tenant is still in occupation, then they still own the goods inside. The goods inside are covered by Torts Interference with Goods Act 1977. It puts the landlord in the category of an involuntary bailee, who through no fault of their own end up being responsible for these goods until they return to their rightful owner. If another person, like the landlord or their agent, sells or disposes of those goods, then the tenant can sue them for conversion, trespass, or indeed negligence. There are a few courses of action a landlord can take, and it would always be best to get legal advice from a suitably qualified person. One way the landlord might want to do this is to get the bailiff to issue a torts notice and complete a torts inventory. The torts notice usually gives 14 days for the tenant to apply for supervised access to come in and remove their goods. If they don't remove the goods within the 14 days, then technically the landlord may be able to sell the goods and use the money to offset the costs of doing this, but not keep it for rent arrears. Sometimes they come back. These days, in 20% of cases, tenants break back into the property, therefore securing peaceable re-entry themselves. On some occasions, the police will help. Other times, they say it's a civil matter. The only way a landlord can be sure that this is not going to happen is to arrange for security officers to be in the property for the first 24 hours or so to try and keep the tenant out. Other methods may include extra alarms or indeed shutters on the property. During the pandemic of coronavirus, COVID-19, the government issued Section 82 of the Coronavirus Act 2020, which placed a moratorium on the landlords from using forfeiture from the 26th of March until the 30th of September. Landlords lost their right to use forfeiture to keep control of rent arrears. This caused many commercial landlords to suffer from tenants who had money but would not pay. The government also extended the days rent that must become due before CRA was exercised from 7 to 189 days, which was another blow. In conclusion, forfeiture is a very good tool for keeping a check on rent arrears, and landlords should use this wisely. Should you require any help, please visit our website and contact us. Thank you for listening.